The Constitution of Argentina, Provisions on Treaty. Article 43. Any person may file an expeditious and swift action of amparo, whenever no other more appropriate judicial means exists, against any act or omission by public authorities or by private individuals, that presently or imminently harms, restricts, alters or threatens, in an arbitrary or manifestly illegal manner, the rights and guarantees recognized by this Constitution, by a treaty, or by a law. As appropriate, the judge may declare the norm upon which the harmful act or omission is founded unconstitutional. When this action complains of any form of discrimination, or regards the rights that protect the environment, competition, the user, the consumer, or rights of a collective nature in general, it may be brought by the affected party, the defender of the people, and the associations that support these ends that are registered as required by a law that shall determine the requirements and forms of their organization. Any person may file an amparo action to find out and to learn the purpose of data about him which is on record in public registries or databanks, or in any private registers or databanks, whose purpose is to provide information, and in case of falsity or discrimination, to demand the suppression, rectification, confidentiality, or updating of the same. The secrecy of journalistic information sources shall not be affected. When the harmed, restricted, altered, or threatened right is that of physical liberty, or in case of illegal worsening in the manner or conditions of detention, or in case of the forced disappearance of persons, the writ of habeas corpus may be filed by the affected person or by anyone else on his behalf, and the judge shall immediately resolve it, even while a state of siege is in effect. Article 75. The Congress shall have power. 22. To approve or reject treaties entered with other nations and with international organizations, and concordats with the Holy See. Treaties and concordats have higher standing than laws. The following international instruments, under the conditions under which they are in force, stand on the same level as the Constitution, but do not repeal any article in the first part of this Constitution, and must be understood as complementary of the rights and guarantees recognized therein: the American Declaration of the Rights and Duties of Man, the Universal Declaration of Human Rights, the American Convention on Human Rights, the International Covenant on Economic, Social and Cultural Rights, the International Covenant on Civil and Political Rights, and its optional protocol, the International Convention on the Prevention and Punishment of Genocide, the International Convention on the Elimination of All Forms of Racial Discrimination, the Convention on the Elimination of All Forms of Discrimination against Women, the Convention Against Torture and Other Cruel, Inhumane or Degrading Treatment or Punishment, and the Convention on the Rights of the Child. They may only be denounced, if such is to be the case, by the national executive power, after prior approval by 2/3 of the totality of the members of each chamber. 24. To approve treaties of integration which delegate competence and jurisdiction to international organizations under conditions of reciprocity and equality, and which respect the democratic order and human rights. Any rules enacted pursuant thereto have higher standing than laws. The approval of these treaties with Latin American states shall require the absolute majority of the totality of the members of each chamber. In the case of treaties with other states, the National Congress, by an absolute majority of the members present in each chamber, shall declare the desirability of approving the treaty, and it shall only be approved by an absolute majority vote of the totality of the members of each chamber, 120 days after the declaratory act. Article 99, 11. He, President, concludes and signs treaties, concordats, and other negotiations required for the maintenance of good relations with international organizations and foreign nations, and receives their ministers and admits their consuls. Article 124, 1. With the knowledge of the National Congress, the provinces may create regions for economic and social development and establish bodies with power to achieve their goals. And they may enter international agreements as long as these are not incompatible with the foreign policy of the nation and do not affect the powers delegated to the federal government or the public credit of the nation. The city of Buenos Aires shall have a system that shall be established for such purpose. Article 129, Transitional Provisions. 1. The Argentine nation ratifies its legitimate and everlasting sovereignty over the Malvinas, South Georgia, and Sandwich Islands and the corresponding maritime and insular areas, because they are an integral part of the national territory. The regaining of said territories and the full exercise of sovereignty, while respecting the lifestyle of their inhabitants, and in conformity with principles of international law, constitute a permanent and unwaivable objective of the Argentine people.